Hi, I'm Jerry Sparks, president of AG Financial Insurance, and welcome to Risk Management Live. Once again, we have Rich Hammar, attorney for the General Counsel of the Assemblies of God and renowned author of Church Law and Tax Report. And today we're going to be talking about clergy privilege, confidentiality, and reporting. What pastors should report and what should be kept confidential. Rich, why don't you just start off, what is clergy privilege?
Well, let's talk about what is privilege. The concept of privilege, it's not widely really correctly understood, but it's a rule of evidence that says this, that while the judicial system in this country relies on full information being provided to the court and the jury to make an informed decision, there are rare classes of evidence that are not admissible, that we don't permit the jury to hear, even though that violates the fundamental principle that the jury should make informed decisions based on all the evidence. So these classes of evidence that are not admissible are generally called privileges. And you're familiar with some of them, the husband-wife privilege, the doctor-patient, the attorney-client, but there's also a clergy-penitent privilege. And each one of these privileges renders conversations between these professionals and their clients, customers, or counselees as off limits, non-admissible under most circumstances in court. And so these privileges are narrowly defined because they violate that fundamental principle that really, and it makes a lot of sense to me, that courts should, in order to make informed decisions, need to have full awareness of all the facts. So these are really in derogation of that fundamental principle.
What is, so actually the clergy privilege now applies in all 50 states, is that correct?
That's right.
And what is the justification for this clergy privilege?
Well, let me maybe just give a little history lesson here, Jerry, to start with. Where did this clergy privilege come from? It is recognized today in all 50 states. It's interesting that probably the earliest European case, anyway, happened in 1605, 1606, as a response to what some of you are familiar with, the gunpowder plot of 1604, in which a group of English Catholics under the leadership of Guy Fawkes hatched this plan to build a tunnel under Parliament. And they had 40 or so barrels of gunpowder that they stored there, and they were going to detonate this gunpowder on November the 5th, 1604, when King James I was going to be speaking to the House of Lords. That plot was disclosed, and it was the plotters, many of them fled, many of them were arrested, they were executed, there were trials. But the interesting thing was that Guy Fawkes and some of the other plotters apparently confessed the plan to a priest by the name of Father Garnet. And Garnet apparently was compelled to testify in court. He refused to do so because of the seal of the confessional, that he received this information, all that he knew about the plot had come to him as part of the confession, a confession. And he believed that it was inappropriate to disclose that in court. The court demanded that he do so. He refused. He was executed. And he has become a martyr in the Catholic Church, a martyr of the confessional. But it started this concept that, maybe clergy should not have to testify about confidential information shared with them in the process of spiritual counsel. So it's interesting that every November 5th throughout the UK is recognized as Guy Fawkes Day, and it was actually a very popular, one of the most popular holidays in the United States during our pre-revolutionary colonial days. We don't recognize it anymore. My daughter, who happens to live in Scotland, there were fireworks going off on the night of November 5th. She, what is going on? And I said, Holly, it's Guy Fawkes Day. So I had to explain to her what that meant.
Go ahead and give us the justification then of this privilege.
So why do we have this clergy penitent privilege that says that any confidential statement shared with a minister in the course of spiritual counseling is privileged? And it's interesting when you look at how the courts have justified this. Let me just share a couple of examples of this. One was the United States Supreme Court itself, in a 1980 decision, said this: the priest penitent privilege recognizes the human need to disclose to a spiritual counselor in total and absolute confidence what are believed to be flawed acts and thoughts, and to receive priestly consolation and guidance in return. And then I think my favorite explanation or justification of the clergy penitent privilege comes from a Minnesota Supreme Court ruling back in the 1930s, where the court said this: "The fundamental thought is that one may safely consult his spiritual advisor. When any person enters that secret chamber, the statute closes the door upon him and civil authority turns away its ear."
Wow.
So the idea is, we think it's socially desirable for people with flawed thoughts, or maybe they want to unburden their souls with regard to some inappropriate action or thought they've had. We want those people to feel free to disclose, to share their burden with a member of the clergy, with in confidence that they're not going to have to share this, or the minister's not going to have to share this in court. So, for example, if you took this privilege away, then people are not going to be confiding their innermost thoughts and failings with their clergy. And we think that's socially undesirable, and I agree with that. And that's the underpinning of this privilege.
What are the requirements of the clergy penitent privilege?
Well, they're basically 5, and really the 4th and 5th have generally been collapsed into one. Let me go through those, Jerry, because it's very important, I think, for ministers to have a clear understanding of this privilege. It does vary somewhat from state to state, but the basic components are generally uniform. And I'll mention a few of the brief differences. Number 1, the first requirement for the clergy privilege to apply is that there must be a communication between the counselee and a minister. Well, that's obvious. You know, you're in a pastor's office and you're in a counseling session. Clearly, that's a communication. But the courts have recognized communications in other contexts as well. For example, letters, telephone calls, cell phone calls. That's an interesting question. What about cell phone conversations? Can they be privileged? There's only been one case where a court has addressed that issue in our nation's history, and that was a few years ago. And it wasn't required to resolve that issue, but it did, as an aside, make a comment that it saw no reason why the clergy penitent privilege would not apply to cell phone conversations. Well, would that apply to text messages? We don't know. There's never been a case. Probably, at least in some cases, I think the answer would be yes. But the interesting thing is, the concept of communication has been extended to mean any act intended to transmit an idea. So, for example, in one case, there was a murder that happened in a major metropolitan area, and the police were looking for the murderer who had used a knife. And this guy runs into a Catholic church, and he finds the priest, and he starts talking. The priest had seen a news account about this murder, and the priest just asked this guy, "Did you commit the murder?" And he didn't say yes or no, but he took a bloody knife out from behind his coat and laid it on the priest's desk. The priest was later asked to testify about that incident, and he was required to do so. At least the prosecutor wanted him to do so, but the court concluded that was a communication because it was an act intended to transmit an idea of guilt. And so the point is, the word communication is broadly defined. Now, the second requirement of the clergy privilege is it must be confidential. And here's where the courts differ. There are basically 2 interpretations of confidentiality. In about a third of the states, confidentiality means no third person is present. So a few years ago, I had a call from a pastor in California who had a member of his church, an elderly woman, who had a neighbor, young man, who had just been to see the movie The Passion of the Christ. And he was so convicted by that movie, he went to his neighbor, who he knew to be a godly woman who was a regular church attender, and confessed to her that he was guilty of 2 unsolved murders in that community. She said, "You need to go see my pastor." He agreed to do so. The pastor called me at noon that day, and he said, "They're coming to see me at 2 this afternoon. Well, if they confess to me, will I be required to testify about that confession?" And in that particular state, I checked out the clergy privilege, and in fact, it defined confidentiality, one of the main requirements of the privilege for it to apply, as meaning no third person is present. So I said to the pastor, if the young man alone comes in and confesses, that's privileged. You're not going to be required to testify in court about that. But if he insists on that woman being with him for moral support or whatever, then it's not privileged. So he never called me back. I never knew exactly what happened, but he understood the law. And the point is, this is true in about a third of the states, that if a third person is present, the privilege doesn't apply. Jerry, it's just like child abuse reporting. I've never talked to a pastor yet that could accurately describe whether clergy are mandatory child abuse reporters in a particular state. They just don't understand the answer to that question. And the same is true here. I've never spoken to a pastor who correctly understood the definition of the clergy penitent privilege under his or her state law. So that's the second thing. Now, but by the way, about 2/3 of the states define confidentiality differently. And they say communication made in confidence to a pastor acting as a professional advisor with no third person present other than those necessary in furtherance of the communication. So you go back to that previous case, was that woman present in furtherance of the communication? Of course she was. The guy wouldn't have come to the pastor without her. So in those states, that would have been privileged. So in about 2/3 of the states, the fact that a third person is present, or a fourth or fifth person, doesn't necessarily negate the privilege. It doesn't make it non-confidential, so long as that third person or those additional people are there in furtherance of the communication. Now, that doesn't mean the whole family's there. I mean, many courts have addressed that issue. Well, what about the whole family comes along? It's not privileged. They're not in furtherance of the conversation. So, but like a husband and wife coming for marital counseling, obviously there's a third person present, but that person is present in furtherance of the purpose of the communication. So again, let me emphasize the importance of understanding what the clergy penitent privilege is in your jurisdiction. In Pastor, Church, and Law, my 4-volume resource, Volume 1 addresses, among many other things, the clergy penitent privilege. But I have an appendix at the end of that book, that Volume 1, that gives the exact wording of the clergy privilege statute or court rule in all 50 states. Now, the third requirement. So the first requirement of communication, secondly, in confidence. The third requirement for the clergy privilege to apply is that it must be a communication to a minister. Now, that's very important. What does the word minister mean? Well, I can tell you what courts have said it doesn't mean. It doesn't mean a deacon. It doesn't mean a member of the church board. It doesn't mean a church secretary. It doesn't mean a pastor's spouse. Many courts have reached these conclusions. And some statutes, in fact, probably over half of the statutes now, clergy privilege statutes among the states, define a minister to include a person who the counselee thought was a minister. So, for example, I've dealt with a number of cases where you have an associate minister, typically a youth pastor, who may not be a credentialed minister, but people think this person's a minister. We call him a minister. And so if you think the person is a minister, you have a reasonable basis for that assumption, then the clergy privilege applies. That person is deemed to be a minister for that purpose. But in general, the person has to be a credentialed minister, ordained, licensed, commissioned, certified, whatever your church calls it. And then the fourth, and I think this is a critical requirement for the clergy privilege to apply, is that it's a communication made in confidence to a minister acting in his or her professional capacity as a spiritual advisor. So at the time of that communication, that minister was acting as a spiritual advisor, not a friend, not a social acquaintance, but as a spiritual advisor. Now here's where the courts have a problem. Many judges, all they can think of when they think of the clergy privilege is the confessional in the Catholic Church. And the idea that you could have a conversation outside of that context is unfathomable to them. So, for example, is it possible for a person to seek out a minister in in the minister's professional capacity as a spiritual advisor at a basketball game, or at Walmart, or playing golf. Many courts they can't comprehend that that's possible. But most of us know, yes, that is possible. You could run into a church member or somebody else at Walmart, and that person, you have a conversation that leads into just a feeling of compulsion by that individual to share with the pastor some innermost thought or failing, and is seeking spiritual counsel. And as long as no third person is listening in, there's no reason why that can't be privilege. But the courts wrestle, they struggle with that, and oftentimes decide that it's not privilege because of the place where the communication occurred. So what I recommend, Jerry, is if you're outside of the church office as a minister, and you're engaging in a conversation with somebody that you've all of a sudden, maybe it didn't start out this way, but it's become really spiritual in nature, confessional, seeking guidance with respect to something, at that point, here's what you can do. You can stop the person and say, may I ask you if you're speaking to me as a minister acting in my professional capacity as a spiritual advisor? And the person said, well, of course I am. That's fine. So if it ever comes to court, if there's in the future some legal case where you're called upon as the minister to testify about what that conversation was, and your attorney jumps up or somebody's attorney jumps up and says that's privilege, and the court's struggling with that, how can that be privilege? Where that took place, at a baseball game, at a Walmart or wherever, at the mall. And you say, well, I know why the person sought me out, because I asked him. And I said, are you speaking to me in my spiritual capacity as a spiritual advisor? And the response was, of course I am. That nails it right there. That is an extremely important question for you to ask in those many contexts where it's outside of the traditional pastoral office where you're engaging in counseling. Now, so that's the fourth requirement. And then the fifth requirement, which is probably only in about a third, maybe a quarter of the states now recognize this, but it must not just be a communication made in confidence to a minister acting in a professional capacity as a spiritual advisor, but number 5 must be in the course of discipline of the church. That, some courts years and years ago said, well, that means it can only apply to the Catholic confessional. And courts have said that you can't limit it that way. It would be unconstitutional to single out the Catholic Church and all the Protestant churches don't get the benefit of this privilege. So what courts have generally said is that the concept of in the course of discipline basically means the same thing as the fourth requirement, that the minister is being sought out in his or her professional capacity as a spiritual advisor. So that takes you through the history of the clergy privilege, the Guy Fawkes gunpowder plot. It takes you through the justification, why we have it. When a person enters that secret chamber, the statute closes the door upon him and civil authority turns away its ear. We've looked at the 4 requirements, that it must be a communication that's not just verbal, that is made in confidence. We talked about the 2 definitions of confidence. 3, to a minister, and 4, acting in a professional capacity as a spiritual advisor. If those 4 ingredients are present, then that is privileged, and what that means is the substance of that communication cannot be introduced in court without the authorization of those parties.
Rich, you've brought a lot of information, and actually with bringing a lot of information comes questions.
Yes.
So let's look at a few questions.
Okay.
Does the counselee have to be a church member for the clergy privilege to apply?
Good question. It's a common question, and the answer is no. Many courts have addressed this question. And again, look at those 4 requirements that I just said. Is it a communication? Is it in confidence? Is it made to a minister? And the key is, was it made to the minister while acting in a professional capacity as a spiritual advisor? The fact that the person's a church member or not is not determinative. That's not part of those 4 requirements. So as the question in these cases is always that 4th one. Was the pastor being sought out in his role as a spiritual advisor? If the answer to that is yes, the privilege can apply, and often does, to non-church members.
Okay. How about if you're marriage counseling and information comes out, does the clergy privilege apply if one of those individuals wants you to testify in court?
Oh, well, number one, the clergy privilege would apply to marriage counseling, as we've said. Generally, it does, except if you're in one of those states where a third person destroys the privilege. But even there, you could argue that its husband-wife privilege applies as well. I've never seen a case that's addressed that in a state where a third person destroys confidentiality and the privilege doesn't apply. I've never seen the case come up where in one of those states it's a couple talking to a minister in marriage counseling, whether that's privileged or not. I would submit that it should be privileged, although I have no precedent to go on because no court has addressed that issue. What was the second part of your question?
Actually, I think what they were trying to figure out, if information comes out, let's say with, I'm guessing that it's something comes out with while they're in marriage counseling, I think they were wanting one to testify, this came out, we found out about this now, and maybe they're going through a divorce or something, and they want to use that information against them.
Well, that gets into the question, Jerry, of who can assert the privilege. And in every state, the counselee can assert the privilege. In probably half the states, the minister can assert the privilege. That's not true in all states. And so the question sometimes comes up where maybe a minister wants to testify about a conversation with a party to litigation, whether it's child custody, divorce, personal injury, who knows what it is. But the pastor, even if a minister wants to testify and ignore the privilege, if the counselee asserts the privilege, you cannot testify even though you want to, if that's the question. Yeah.
No, that's great, because actually that's one of the questions here. Is there a duty of confidentiality? So if they want, if somebody comes with you with some information, sort of like the Guy Fawkes thing, somebody's going to, kill the king or kill the president.
Or kill their spouse.
And they want to tell somebody, can they?
Well, that's a very good question. And there have been very few cases that have addressed that, but there have been some. And I would just make a few comments here. Number one, you have the Tarasoff case in California Supreme Court several years ago, involving a psychiatrist who had a patient that was overtly suicidal. Not suicide, in that case, I think the person wanted to kill somebody and threatened to do so. And the psychiatrist did not disclose that to anyone, including civil authorities and the psychiatrist himself had the legal authority to involuntarily commit this person and did not do so. Well, the counselee, the patient ended up, in fact, carrying through with the threat and murdered a person. And so the question was, could the psychiatrist be found liable? That is the Tarasoff case. There's only been a handful of these cases, but the same principle applies to clergy. What if you receive information that somebody's suicidal? Well, that was the Nally case back in 1990. The California Supreme Court said, if you're a non-therapist minister, you are not legally required to share the fact that a person in your church that counsels with you is overtly suicidal. You do not have a legal duty to refer that person to civil authority that can involuntarily commit that person. That's not to say you shouldn't, but at least in California, that answer has been resolved in favor of there is no duty to refer that person. You can deal with that matter as a spiritual issue, as long as you're a non-therapist, meaning you're not a state licensed or recognized psychotherapist, counselor, etc. Now, the related issue in these cases is, can a minister be, well, let me just talk about this. The duty of confidentiality is not the same as the clergy privilege. They are related because the concept of confidentiality is part of the clergy privilege. But the clergy privilege, let's be clear here, only applies to judicial testimony, whether it's in a deposition or in a courtroom testimony. It doesn't apply in any other context. But the duty of confidentiality applies in all contexts. And what that means is people shouldn't disclose confidences they receive, for example, in communications with a minister, to anyone, whether it's in court or out of court. And some ministers have been sued because they have disclosed confidences they've received in counseling with others. In some cases, This has involved telling the congregation, if you can believe it, what somebody shared with me. One case involved a lady that counseled with her pastor and disclosed that she had been severely sexually molested by her father when she was a young child. And the pastor shared that with the congregation in order to prevent her from being elected to the church board. I mean, it's just stunning that this kind of thing happens. And so, but there are many ways this can happen where a pastor will disclose, maybe tell the authorities about a potential crime. And I'll tell you, I've studied these cases. There have been 9 of them in the history of this country where ministers have been sued for breaching the duty of confidentiality. In only 3 of those was the minister found liable. In 6 of them, the court concluded there's no duty to maintain, there's no duty under those circumstances that is breached, and you cannot be civilly liable for sharing confidences. It's a moral, it's an ethical imperative that you not disclose confidences with others, but it's not a legal duty. It's an ethical, not legal. So I think most ministers would agree, even if it's not a legal duty, that I not disclose confidences with others. As a matter of ethics, I decline to do so. In fact, I would say that there are many things that ministers can do to marginalize or limit their ministry, but there are a few things they can do to destroy it. And those would be sexual misconduct, financial impropriety, and I believe sharing confidences. And so I think there's a high ethical duty that a few courts have recognized has made the leap to a legal duty. 3 cases in the history of this country, in recent years, by the way, in which ministers were found liable in a civil court for sharing confidences. But so I don't want you to think this is a huge risk. Legally, it's not, but ethically and in terms of your professional status, I think it's a critical issue.
So actually then, a pastor that does share information should not, in most cases, be held personally liable for releasing that information, but from a legal standpoint, but ethically, you're saying, let's not do that.
That's right.
Okay. Now, one of the things...
And by the way, you're not going to be liable if you don't share. So if somebody confesses to you that I murdered somebody, you are not required to disclose that to anybody. And that's a very difficult question. The only crime that you're legally required to disclose in many states, not all, is child abuse. If somebody confesses to child abuse, either they're the perpetrator or somebody they know, or they're the victim. In many states, clergy are mandatory reporters and have a duty to report that. But that's the one example where a confession of a crime, the minister is legally obligated to report that. But if it's murder, if it's rape, if it's armed robbery, terrorism, the answer is no.
So the one exception then to clergy reporting comes with child abuse, and every, I know that most states have specific rules for, for everybody reporting child abuse, whether no matter what, position you hold, but clergy is not exempt to that.
No, clergy in most states, I think it's 41 by my last count, are mandatory reporters of child abuse, meaning they are legally required to report. Now, in many of those states, you are not required to report information you learn of in the course of a privileged conversation. But you got to be careful there, because a lot of conversations you may think are privileged, but they're not. There may have been a third person present, and you're in one of those states that define confidentiality to mean no third person. So, or was the person really seeking me out as a spiritual advisor? Reasonable minds can differ on some of these issues. So it's a legal conclusion you're making here. And so I recommend you always err on the side of reporting child abuse if there's any suspicion. Do not hide behind the clergy privilege and just assume that's going to, and even if it does apply, does that mean, that just means you're not legally required to report, but you're still encouraged to report. And that's why in the vast majority of cases, privilege or not, I advise clergy to report suspicions of child abuse.
Rich, I want to again thank you for your time. Gosh, this is a great subject for our audience, and your knowledge is just so beneficial to all of our pastors and all the people out there watching. So we want to thank you for watching Risk Management Live.